Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 2904, Devon Energy Production against Sheppard from DeWitt County and the 13th Court of Appeals District. Justice Young is not participating in that case. Then 21470, Collin Creek Assisted Living Center against Faber from Collin County and the 5th Court of Appeals District. And finally, 21874, American Campus Communities versus Berry from Travis County and the 3rd Court of Appeals District. The court has allotted 20 minutes for each side in each of the three cases, and will conclude the arguments before lunch. The arguments are being live cast this morning and will be available in the court's archives later. Justice Devine cannot be present this morning, but expects to participate in the decision of all three cases. We'll begin with 2904, Devon Energy versus Sheppard.
May it please the court, Mr. Watson will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court, it's good to be back. This is not another post-production cost allocation case. It is not even the first add-back clause case. We are here because the Court of Appeals actually held that because value increases after the first sale until it gets to a market center where it's sold by third parties, it is not unreasonable to construe the leases as ensuring the lessor's royalty is based on the standardized value of gas at the market center. And that is effectively what the Sheppard and Crane leases accomplish. You do not have to get into the battle of arcane language of what this contract means to resolve it. This case should be resolved by going back to the principles this court announced in Heritage. And the same thing that went wrong in Heritage went wrong here. In Heritage, this court held that the Court of Appeals disregarded the fundamental meaning of what constitutes a royalty and also market value at the well. But in Judas decided the same day, it defined gross proceeds. And here they completely ignored the meaning this court gave gross proceeds. And that has implication. Every case, all six that have flowed out of Heritage have made that basic mistake of forgetting what the basic meaning of royalty and gross proceeds is assigned by this court and not directly addressing it. So we're going to talk about—
The parties could agree for a royalty based on the post-processing market value, couldn't they?
Oh, absolutely. Heritage said, Your Honor, that if the parties want to, they could specifically say, we are changing the point of valuation. The point is, they didn't say it. They didn't say changing the point of valuation. I'm going to talk about the two principles first that are dispositive. First, the court gave meaning of royalty that's basic. It's the landowner or the royalty owner's share of proceeds, ordinarily bearing cost. That's the meaning it gave in Heritage. In Judas, it made it clear that gross proceeds are, in fact, the proceeds the lessee receives after selling the product. It ignored, second, It ignored the burden this court placed on anyone wanting to change those fundamental dimensions to come forward and do it specifically, clearly, and what the court as early as 1953 called plainly. This is what gets away from the opaque language this court is asking parties to get away from.
But is it not plain to cite those two cases by name and page number?
This court said it isn't, Your Honor. When you get back to Burlington and Bluestone, this court went through and said, and this is my point, it's not enough to say over and over as they did, free of cost. It's not enough to say free of these specific costs. And finally, the court specifically said, I believe it was in Hyder, but it certainly carried forward in Burlington and Bluestone, just saying heritage doesn't apply is not enough. Why? It's not enough because saying that doesn't address the problem. You're adding something to the royalty that has never been part of the definition of royalty. And if you're going to start changing a fundamental principle of law of what a royalty is, or what gross proceeds are, i.e., what is actually received by the seller in the first sale, then you have to directly address that. You can't come at it through the back door. You can't do it by inference or implication.
But you can call it a royalty, or not.
Well, of course.
But you say it's fundamentally different from a royalty.
When you start saying we are going to be paid royalty on the cost incurred by third parties downstream, that has nothing to do with the royalty owner's share of production. That's the point. You are expanding the definition beyond what I'm entitled to historically and in the industry of my share of production. You're saying I'm entitled to my share of production plus. Now,
But the parties can agree to that and call it a royalty, or not.
yes, they can if they define it. That was the point. The whole point of heritage and its progeny is if you're going to do that, spell it out. Don't do it by implication. Second, who has the burden of doing that? The Court of Appeals said if the parties intended to limit additions to the royalty base so that they could never exceed gross proceeds, which is what they would do here, they could have easily said so. The issue is who has the burden?
So, looking at paragraph C, 3C, which I take to be the primary basis for the other side's view of how this works, what is an example you can give of where 3C, and in particular the cost shall be added back to the market value or gross proceeds? Can you give an example of, under your view of how all this works, when would that happen? When would that part of 3C come into play?
Well, first, because it's gross proceeds, the point is that's surplusage, and the Court of Appeals did backflips to keep it from being surplusage. But there is one example of where it could occur, and that would be the example we gave in the briefing of where if the stream of production, if the producer had the purchaser, the first purchaser that generates the gross proceeds, take over the producer's cost of transporting, for example, and give a lower price because the purchaser absorbed the cost of transporting to the first purchaser, then that would be an indirect expense. What this is trying to do is what all of these have been trying to do is get around the sale to the affiliate, the sweetheart sale, where someone is really not paying a fair market price for the product. There is a duty on the seller under gross proceeds to get the best price available. And that's why the industry is turned to NYMEX, because that price floats on a daily basis. And just like Justice Heck dealt with in Hyder, where the royalty was based on an aggregate, a composite of third-party sales averaged out and backing out expenses to get to those third-party sales after the first sale. That's what is happening here. The NYMEX just backs out the sales after the first sale. But here, the issue is, if you want those costs that are backed out, who has to say it? Well, this court made it clear as early as 1953 in Bars versus Scharnbeyer, and most recently in Winsky. Parties are free to contract for whatever division of interest suits them. Their intent as expressed controls. But if they want their agreement to operate differently from the basic principles of mineral conveyances, this court has said they should do so plainly and in a formal way. Saying any contract or indirect expenses is not plainly and in a formal way. That is exactly what this court went after in Heritage, saying that free of cost, which is a lot clearer, isn't enough. You've got to say, we understand that a royalty is the landowner's or royalty owner's share of production. But we are changing what royalty means by saying it's royalty plus these costs that third parties incur after the point of sale, after the lessee loses title, loses control. This court has said that once we get to a gross proceeds point of sale, once it's delivered there and the money is paid, the lessee's duty ends. And it does. And it has absolutely no control over what happens afterwards. None. That is in the hands of the third parties. It doesn't know what those costs are, and it has no control over them. That's the reason the focus has to be, and historically in every single case this court has had before it, every one, the focus has been on from the wellhead to the point of the first sale. No case has ventured out of it. That is the reason that the court repeatedly said in Heritage and in every case after, we look to what we have said cabins the terms that we use, that the industry necessarily adopts. And Heritage repeatedly said, stability in the industry, consistency, and predictability require that these terms be given the same meaning every time, unless you specifically say otherwise. And one example was, if you want to change the point of sale, you can do so, but you have to do it plainly and clearly and not obliquely or impliedly.
We're told in the briefing that so-called add-back clauses are more common these days, or have become more common. Is that true, and is this language typical of such clauses?
The language varies, Your Honor, but this is important because this was prepared by a law firm the first lease was signed about 22 months before the discovery well in the Eagleford. And in this case, they said in the summary judgment hearing that these are a couple of little cases, but they've got 200 more identical ones following it. So for the purposes of this, we've got a bunch of them out there, but they do vary. They do vary. But again, the add-back clause seen in historical perspective is just another attempt to say free of cost. That didn't work. Say free of these specific itemized costs. That didn't work. Saying notwithstanding heritage. That didn't work. Now trying to say, okay, those didn't work. If you charge it, add it back. But that's not where we are. This case is saying, can you expand? If you charge it, you have to pay it back to be more.
So what would work?
What would work?
Yeah, give us your best example of the kind of language that would result in the outcome that the respondents argue should happen here.
Instead of using terms like any contract where you've just defined the contract as the contract of first sale, and in the very next clause of that say, so that it won't be charged back. Instead of doing that, you directly hit it. And if I were drafting it, I would say, we understand that a royalty is limited to the share of production. We understand that gross proceeds are the amount actually received by the lessee. We are, under Winsky, we are changing that. We are changing it so that royalty is the share of production and all of the costs to get it to the market center, or you could do it another way, exactly what they said could be done in heritage. You could say, we understand gross proceeds are at the point of first sale, that the duty ends there, and that's where everything's calculated. We're changing that, saying the poor lessee gets the gross proceeds from the first sale, but we get a royalty based on the sale at the market center. That would do it. That would be clear. That would be what this court held. And I'm wondering why they didn't say it that way.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Mullins will present argument for the respondents.
Mr. Chief Justice, good morning. May it please the court. This court has repeatedly recognized the party's right to freedom of contract and to make decisions about how and whether royalty owners may bear post-production costs. And this court has given guidance on how to do that. Justice Owen told us you can add to the value of your royalty. She provided the roadmap. This court has also recognized that oil and gas leases are simply contracts, and that it will ascertain the party's intent by examining the plain meaning of the words the parties chose to use in their agreement. There are no bedrock principles which supersede the party's intent as reflected by the words they chose to use. The respondent royalty owners are simply asking this court to enforce the lease as written, and that is where petitioner sales contracts plainly include reductions or charges for certain post-production costs, that they be added to their gross proceeds so that respondents do not bear these expenses directly or indirectly.
So what is your response to the petitioner's argument that this just doesn't do it?
Well, my response is that they're completely wrong. I think if you look at what Justice Owen said in Heritage, she clearly said you can add to the value of your royalty base, and this tracks exactly what she said. If you look at paragraph 3C, it says add to. The phrase add back appears nowhere in this lease, and I'll talk about that in just a second. But
The thing about 3C is that if you read it your way, it seems to change the nature of the royalty such that 3A and 3B are a distraction at best. I mean, it's a tail wagging the dog sort of thing. If 3C is really where the royalty is described and is doing the work of telling us what kind of royalty this is, 3A and 3B say a lot of stuff that just really never, doesn't mean very much.
well, and I think
It's a
that's
strange way to set this up, to have paragraph C really the entire ballgame.
Well, I think that's why the Court of Appeals called it a proceeds plus lease, is that you have to start with an initial calculation, and that's A and B. A and B says the initial royalty is gross proceeds. But then if 3C is triggered, which we'll see, if there are reductions or charges in their sales contracts for post-production activities that they alone elected not to perform, then you add those to that royalty base so that respondents still get the benefit of their bargain and they're not bearing those expenses. But before I get to the lease language, I would like to provide just a little bit of context. And that is, the petitioners throughout their briefs offer their positions to the court as to what the parties intended. But they're like the third or fourth assignees under these leases. They weren't in the room when these leases were negotiated. They have no ideas what the parties' intent was. The only record evidence of intent is from the respondents. When Mr. Sheppard's father and the Crane's father crafted this lease language, Heritage and Judas was fresh on the books. And we know that those cases examined how market value at the well is calculated. You can take a downstream sales price and net out reasonable post-production costs to arrive at an approximate value at the well.
So if there is a market inversion like there was a couple of years ago, you're saying that a lessee that earned no gross proceeds would nevertheless owe a royalty on the expenses that the lessee and others incurred up until the point the oil and gas was unloaded. In other words, they obtain negative gross proceeds, and they zero gross proceeds, lots of expenses. The lessor gets a royalty on the expenses?
Well, for that brief moment of time where everything inverted, if there are no gross proceeds, there are no gross proceeds. But
right, but that does, under your construction, are you saying it doesn't matter if the gross proceeds were zero to the lessee because you're owed a royalty on every expense incurred up until it sold for something at market?
If their sales contracts that rendered them receiving zero gross proceeds but still included reductions or charges for these activities.
Right, but I'm just saying, assume it was rendered valueless because of the costs associated with producing it by the time it got to market. Mm-hmm. Are you saying that, I mean, it seems like your construction doesn't have anything to do with what the gross proceeds are and has everything to do with what expenses are. So you would owe, the lessor would have it and be entitled to a royalty just based on the accumulated expenses.
If those expenses are included in their sales contracts, then yes. And if those expenses are only for these enumerated post-production costs, then yes, that's exactly what this lease was intended to do.
And so it seems unusual that it would all come down to how that final market sale is papered, is accounted for. Because you're saying if there are reductions or expenses in the contract, you get those. But if they're not, you wouldn't. And it's functionally, it'd be the same transaction. So you could sell it for 80 without mentioning costs, and you'd get a piece of the 80. Or you could sell it for 100 minus 20, and your position is you get a piece of the 100. And the only difference is that we mentioned costs in our contract.
And that's really what the Court of Appeals focused on. And I'm not sure, if they sell it, I hate to give them suggestions on how to do this, but if they sell it for 80, they sell it for 80. There are no reductions or charges
And so
in that price.
what's the economic sense of there being a difference between your royalty on a sale for 80 and your royalty on a sale for 100 minus 20? And the only difference is some accountant or lawyer happened to put another line in the transaction document.
Well, the economic sense behind that is to make sure that they don't find a way to continue to manipulate who is bearing these expenses. Let's be clear, if they perform these activities themselves, if they do the enhancing activities themselves, which they could do, they bear 100% of those expenses. They also get the enhanced value. Instead, they choose not to perform those activities, and they manipulate in their sales contracts how that expense is passed on to the respondents. That's exactly what paragraph 3C was intended to prevent.
But don't you take care of that with sales to unaffiliated parties?
Not alone, because that would just look at gross proceeds. 3A and 3B only calculates gross proceeds. And so
But
if they're
the
baking,
manipulation aspect, assuming that it's an unaffiliated third party, they wouldn't have any incentive to incur expenses that would ordinarily be the expenses of the lessee, would they?
No, they don't. That's why they shift those expenses to the petitioners. Let's also be clear. These are not expenses of the third party. These are the petitioner's expenses they are bearing directly at the point of sale in contract. They are expenses for post-production costs that they elected not to perform. And they bear them in contract by taking a reduced price.
So in your bench book, Exhibit 4, you have an example of the contract language where you've highlighted that lays out, here's the price you're paying, minus $18 gathering and handling, including rail car transportation. And your position is that minus is a reduction or charge for the expenses or costs for one of these enumerated activities under paragraph 3C. What if instead this contract had merely said minus an $18 agreed discount by the parties?
And there's plenty of those that were at issue at the Court of Appeals, Your Honor, and we lost on those. And so
Okay,
we've lost on a majority. We're already kind of limping in
If
here.
it doesn't specify that it's minus for one
Right.
of these enumerated things, if it just says an agreed discount
Sure.
of $18, then you wouldn't get the benefit of that value?
According to the Court of Appeals, no, we wouldn't. Of course, I disagree with that for many respects. And one is, you know, if it walks like a duck and it quacks like a duck, it's a duck. Whether or not they call that minus $18 transportation or not, that's exactly what it is. And we know that because they're pegging it off of a downstream index price. And so, but when they reduce the index price, that's further evidence that it's for a post-production cost. But they get around that, and I think we'll see that probably after this. They're going to delete the word transportation or marketing and just say minus $18. And the Court of Appeals reversed us on that because it said there just wasn't enough evidence in the record to show what those unenumerated charges were for. Also, I think you can look at the exact contracts that call it what it is. It says it's transportation, you know, and you can see it's the same product being sold at the same point to sometimes the same parties. Whether or not they call it transportation or not, that's exactly what it was for, but that's not the issue
Or the
before us
other, I
today.
guess, example or position under paragraph 3C is, even if it says agreed discount, whatever it is not severance or production taxes, which the last sentence of paragraph 3C says, the royalty shall never be chargeable for anything other than pro rata share of severance or production taxes. Was that your argument in the Court of Appeals? Was even if it's not enumerated as one of these post-production activities, it's not severance or production tax?
That's correct. We did not argue that that $18 unenumerated charge was for taxes. Correct. And if we
This
could,
is the definition of gross proceeds in 3B. Is that in some tension with this idea that the royalty is going to be based on a number that has nothing to do with what the operator received, what the working interest received?
I don't think there's any tension
It
between.
says, mean consideration received by the lessee for disposition. If he doesn't receive it, how can it be gross proceeds?
Well, A and B alone are dealing with the calculation of gross proceeds. 3C is a wholly separate calculation that is done.
So what I'm asking is, does 3C overrule the definition of gross proceeds in 3B?
It does not, no, Your Honor. It supplements and adds to. It's adding to what the calculation of gross proceeds in A and B.
But if the numbers that go into the royalty calculation were for money never, for consideration of money never received by the lessee, doesn't that override the definition?
I don't think it does, Your Honor, because 3C solely looks at reductions made to gross proceeds for expenses. We're not appending 3C to B and then just saying, disregard it. It's saying value these expenses and then add to it so that we get our proportionate share and we don't bear them, which is exactly what 3C was intended to do. And if I could,
Didn't the parties contract in paragraph L of the addendum to override paragraph 3? To the extent that shall be controlling over the provisions of paragraph 3 to the contrary, and this paragraph shall not be treated as surplusage.
Right, and we don't think that the addendum paragraph L certainly doesn't modify or contradict 3C in this case. What addendum L is doing is it's saying, hey, under A and B, the petitioners, however you decide to improve the value, if you transport it or process it, et cetera, then L makes clear that only the lessee bears these specific costs under A and B. What it also does, as you mentioned to the petitioner, Justice Busby, is that it makes clear that the parties knew what Heritage and Judas stood for, and that they agreed that no one would stand up here today and say that these royalty provisions are meaningless surplusage, which is exactly what the petitioners are standing up here and doing. It shows the party's intent to allow the royalty base to be enhanced by the value of these post-production costs. And if you look behind tab 2 of our bench brief, this is exactly what Justice Owens said could be done, where she said there's a number of ways the parties could have, provided the lessee was to bear marketing costs, if they had intended that in addition to the payment of market value at the well, the lessee would bear all post-production costs. They could have said so. There's no direct statement in the leases that the royalty owners are to receive anything in addition to the value of their royalty. The value of the royalty and heritage was market value at the well. So we know it's possible to receive royalty beyond the point where the lessee chooses to sell it. And I do want to draw your attention to the illustrations behind tab 3, because I think that they make this contract manipulation abundantly clear. The first is really just an illustration showing how the respondent's interpretation harmonizes and gives effect to 3A, 3B, and 3C, unlike the petitioners who give 3C zero meaning and write it completely out of the lease. And so I'll just show you that the expenses between the wellhead and the point of sale are governed by 3A and 3B. We know under Hyder, we know under Bluestone, that when proceeds are valued in gross, they're valued at the point of sale without deduction of the lessee's post-production costs. That's what 3A and 3B stand for. There would have been no reason to include paragraph 3C if this was a simple gross proceeds lease and we were only worried about deductions between the wellhead and the point of sale.
Well, I think the other side says that 3C is there to sort of guard against manipulation in the original sale that would, conventionally give rise to the gross proceeds. You could do some sort of manipulation and take a lower price and have somebody else bear the costs, and then you're functionally, it's functionally a net royalty if you paper it that way, and that's what 3C is guarding against. That's what they say.
That's what they say, but 3C clearly speaks to the point of sale. And so everything that happens pre-sale, all their page 15 examples they gave you in their brief, what's fatal to that offering is they say that those are all costs before sale, before the sale. 3C looks at the point of sale and say, are these reductions or charges borne at the point of sale? If so, then you add them to the gross proceeds. Also, 3C,
Could the provision mean to capture expenses incurred by affiliated purchasers as opposed to non-affiliated ones?
I don't think so, Your Honor, because this clearly says that we get gross proceeds to the first unaffiliated purchaser. And so the gross proceeds would indicate, it doesn't matter what happens before then. And if turn to scenario 1, as my time is running out here, I do want to make clear, scenario 1 behind tab 3, this shows what would happen if the petitioners decided to perform these enhancing activities themselves. It's clear that they would bear this $20 transportation charge, and they would receive the enhanced value of $100. In this example, the royalty would be $20. They would net $60, $100 minus 20, minus the $20 charge that they and they alone bear to get it there. But
in that case, would the unaffiliated purchaser then, the shift of the expense, if it's a fair market value transaction, doesn't really, in the end, affect the gross proceeds, right?
Right. In this example, there probably may not be a reduction or charge. It would probably just be a price. So there would not be a reduction or charge included. But if you look at, to make it crystal clear, under scenario 3 behind this tab, this shows, what if instead they decided to sell at the well? And what they do is they net off that debt. By the way, the reason why we're even talking about market center is the Court of Appeals did not change the point of sale to some far-flung market center. The reason why we're talking about it is because that's how they chose to negotiate their contracts. That's how they chose to approximate the value at a point of sale upstream from the market center. And so,
could you have written the agreement to say that the lessee will undertake particular post-production expenses? In other words, I think your point is that the lessee's offloading, but they're offloading to a third party in a fair market transaction. Mm-hmm. So assuming the price takes care of that. But you're saying they're not allowed to do that at all, no matter that the price takes care of it, because they're supposed to be handling these expenses. It would seem then that you're basically demanding that they undertake some kind of post-production.
Not exactly, and I do want to be clear. We're not demanding that they perform these enhancing activities. These leases are designed to be very flexible. They can choose to sell anywhere from the wellhead to the burner tip. That's their decision. If it makes the best business sense economically, that's fine. But what 3C says is, if you choose not to perform these activities, great. Had you done them yourself, you would bear them. But if you choose not to and instead farm them out to a third party to do them, then you can't shift in your sales contract and manipulate who's going to bear that expense. And that's made clear here in scenario 3. They sell at the well, they peg it off the $100 and they net out $20.
But the shift would be reflected in the price if it was a fair market value transaction, wouldn't it? Or
that's the fair market value for the product at that location, right?
well, at the time of the sale to the first unaffiliated purchaser.
Right, and if that sales contract, even though it's fair market for the product at that sale, if the contract is arriving at that fair market sale by netting out a post-production cost that they've elected not to perform, and that's fine if they don't want to do it, they just have to add that expense to the fair market price they receive so that we don't bear that portion. If they net out $20, our 20% royalty is going down $4. And so if they don't have to add expense, if they can't deduct expenses between the well and the point of sale, but they can deduct expenses at the point of sale, then they're incentivized just to sell to a third party and do none of these enhancing activities. And that's what this lease was designed to prevent. Your Honor, as my time does come to a close, I do want to say that, if this court says that we have freedom of contract, but it ignores the language of the lease, if it ignores heritage, which told practitioners how to achieve the result that they want, then how is that true? Was Justice Owen right? The respondents should get the benefit of their bargain. The petitioners urge a construction that renders an entire provision meaningless, violating a fundamental tenet of contract construction. The plain language the parties crafted requires that any reduction in their sales contracts, no matter the point of sale, be added to their gross proceeds, so respondents do not bear these expenses. And for these reasons, the judgment below should be affirmed.
Any other questions? Thank you, counsel. Mr. Watson, you have 5 minutes.
Thank you, Your Honor. May it please the court. We heard some critical things there. First, I think I heard it said that there are no basic fundamental principles in oil and gas that need to be directly addressed. That is precisely contrary to everything this court has written, and particularly contrary to heritage. Heritage could not have been clearer in saying that the mistake the Court of Appeals made at 121 was ignoring the definition of both royalty and, in this case, to transpose Judas, gross proceeds.
What is your response to the argument that the lease is intended to remove the incentive to offload ordinary lease enhancing activities that a lessee ordinarily would undertake?
Well,
and thus, calculating the royalty off of a lower price.
That may be what it was intended to do, but let me use the example that they used, the $18. That is for oil. That is for rail car transportation of oil. Oil is at the tankage on the lease. It's sold when the spigot is turned. There is no transportation cost. There is no rail car to get from the wellhead to the tank where they turn the spigot at the point of sale. The $18 is what NYMEX backs out for the buyer's transportation to the market center. That is what they're calling something that we have foisted on them. We did not. That is simply the reduction to get a the best price possible, which is the NYMEX price, you have to back out what the buyer pays to get to that higher price. And that's the whole point of what the Court of Appeals did. It said, because the price is higher because of these expenses that third parties bear, we think you should have to pay royalty on those expenses to the effect that you're getting the actual NYMEX price instead of the first sale price. Well, everybody knows the first sale price is less. Of course it's less. Of course there are going to be expenses to refine. Of course there are going to be expenses. That's not doing anything untoward. That's just saying, here's what it's going to cost to get up there. We've got to back that out if we're going to use NYMEX as the gold standard.
If that distinction that you just set up is resolved, does that answer the 23 situations that you presented to the trial court?
Oh, yes. I mean, that's the point.
So we don't have, nobody has to go back through contract by contract. The general answer would answer all of those questions.
Your Honor, that's exactly what Justice Owen addressed at page 131 of her opinion, where she said two things. One, if you want to change the point of sale, the point of valuation, you can do it. But say so. Say that's what we're doing. Say what the Court of Appeals said it effectively did. No, effectively won't cut it. Merely reasonable won't cut it. You've got to say it. That was the point of Winsky. If you're going to do something that has never, ever been done in oil and gas or in the industry.
So why isn't the last phrase of 3C clear enough under the standard you're promoting? I mean, when it says lessor's royalty, set aside all the first part of 3C, but the last phrase, lessor's royalty shall never be chargeable directly or indirectly with any costs or expenses other than pro rata share of severance or production taxes.
That's right.
Which is not at issue. So it shall never be chargeable with any costs or expenses, period.
The
Why isn't
royalty
that clear
is
enough?
defined as gross proceeds received by the lessor. Those gross proceeds are not chargeable. You know, the Court of Appeals admitted we charge no post-sale prices. And to Justice Heck's question, right after Justice Owens said that if you want to change the point of valuation, you can. She said, if you don't do it that way, it will lead to a fact-finding inquiry in virtually every case as to what is a cost to market gas. That's what those 23 items are. What we are saying is cut that off by making it clear who has to say royalty plus. Thank you.
Any other questions? Thank you, Mr. Watson. The case is submitted, and the court will take a brief recess.